Today's lecture covers one of the two potential public forum resolutions for September-October, probable cause searches in public schools. This is the resolution, this is the topic I should say, that is being used over the summer by most of the debate camps, and some people say that it has the best chance of winning in the fall. I will do a lecture on the other topic, but I'm starting with this one since it's the one that has had the most traction over the summer. The resolution for the topic is, in the United States public K-12 schools, the probable cause standard ought to apply to searches of students. What is this resolution about? First of all, it's about the pros and cons of searching students in schools. And these searches are searches that are conducted by school administrators for the purpose of finding evidence of kind of contraband of things that you're not supposed to have in schools, such as drugs or guns or other types of weapons in most cases. The second thing the resolution is the legal standards that govern those searches, particularly whether or not probable cause should govern the searches. But in order to understand whether or not probable cause should govern the searches, it's very important to understand legal standards that govern them. And of course, this is intricately related to the courts and what legal standards have been established by the courts. You will learn a lot debating this topic. You will learn about your rights in school and how the law applies. You will learn about responsibilities and obligations of school administrators. And you will learn about how the courts work, particularly the Supreme Court and other federal district courts that have interpreted the law in this area, and to some extent state courts, because states can establish their own laws as long as they provide rights that are at least as high as what we would call the federal floor of rights that are based in the Constitution. The states can provide additional rights beyond that, and you might find some evidence in states court cases related to the topic that you can use on both sides. In today's lecture, I'll cover the terms of the resolution, which integrates a lot of the controversy and background and relevant court cases to the area. I'll discuss the pro and con arguments on both sides and offer a few strategic considerations for both sides as well. Now, in the terms lecture, which is where I'm going to start, covering the terms of the resolution is going to take a substantial amount of time, but it will integrate a lot of the controversy background in court cases. But let's start with some of the terms, and at least let's start with the easy ones. First of all, we have the United States, which simply refers to the country that you're most likely in at the moment attending debate camp in the United States or preparing at home for your fall debates. This is relevant because we're really dealing with U.S. constitutional rights. Now, what are public schools? Public schools are taxpayer-funded schools that anyone can attend. These schools are free. Anyone can go to them. Now, this is very important that they're public schools because employees in the schools work for the government. And of course, the purpose of the Constitution is to protect our rights against the government. So we have free speech that the government can't restrict. We have a right to be protected against unreasonable searches that are conducted by the government. Those rights are not necessarily rights that you have against other people in private settings. For example, your employer can restrict your free speech rights, what would normally be considered, I should say, your free speech rights, as part of your contract. So, for example, if you go out and you say something inappropriate, you say something offensive, your employer could fire you for that or penalize you for that in some other way, whereas the government couldn't, because you have free speech rights to speak out and the government can't penalize you. But those rights that you have do not apply to private parties or against other parties, and sometimes that can get confused. You'll see stories in the media where somebody gets fired, a famous person gets fired maybe for something they said on social media, and they say, well, my First Amendment, they get fired by their employer, and their employer is a private employer, and they say, hey, my First Amendment rights were violated. I said this, you shouldn't be allowed to restrict my speech. No, the company you work for can restrict your speech as per the terms of your contract, but it's just that the government can't. So again, I want to emphasize it's very important that we're dealing with public schools. K-12. K-12 refers to grades kindergarten through 12. That's important to emphasize because we're really dealing in most instances with people who are considered to be minors under the law. We're not, there are of course some people who are 18 when they are seniors, but we're generally dealing with people who are minors under the law. This resolution does not apply to public universities where you're dealing with adults, which would create arguably a different set of legal standards. But now let's start looking at some of the more difficult terms in the resolution. Search. There's a couple ways to understand a search, and they're both very important to understanding the topic. The search in its common usage just refers to when a person searches or looks for something. So if you start looking through my bag, that's you're searching through my bag. You may lose something, you may be searching for it. That's how we understand a search. But under the Fourth Amendment, a search happens when the government violates privacy. This is from U.S. v. Katz, which is one of the most important kind of foundational cases in how the court currently interprets the Fourth Amendment. They held that the government's activities in electronically listening to and recording the petitioner's words violated the privacy upon which he justifiably realized while using the telephone booth, and thus constituted a search, and it says and seizure, within the meaning of the Fourth Amendment. In this case, dealt with with eavesdropping on a defendant in a phone booth, an old-fashioned phone booth back in the 1960s, and they said that the government violated this person's privacy, which they later went on to define as kind of a reasonable expectation of privacy, and because the privacy was violated, a search was conducted. Then we see that once this is determined by, say, by a court, then the government has to justify that search and why it was reasonable. So let's move on to kind of the Fourth Amendment and how the government interprets it, because the Fourth Amendment is the amendment to the Constitution that's relevant to a search. And as we can see, the Fourth Amendment is laid out. It's stated in the Constitution as the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause. All right, the first time we're seeing in this discussion the term that's in the resolution, that's where it comes from, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, the courts have to interpret the Fourth Amendment, right? The amendments to the Constitution, you can look how short this amendment is. This is just a sentence. You can go look at the other amendments to the Constitution. You'll find other very short amendments that have just a sentence or a few sentences to describe what's protected by the amendment. So then the courts have to go and interpret that Fourth Amendment as applies, how it applies to particular situations. Because look, for example, the Fourth Amendment doesn't say if the school officials conduct a search based on probable cause or any other standard, right? It doesn't come out and say how this applies to schools, how it applies to minors. Courts have to interpret persons, houses, papers, and effects. Originally, when the courts interpreted this prior to the Katz decision, they just interpreted to protect against searches of property. Katz was the first to say it applies to any search of a person, not necessarily property, and a person is more than a physical thing, such as eavesdropping it. The court also interprets the Fourth Amendment to protect privacy, right? As we'll see in the holding of these other decisions that are related to school searches, they're talking about privacy and protecting privacy and whether it should or shouldn't be protected in particular instances. The Fourth Amendment itself doesn't say anything about privacy, all right? Doesn't say anything about privacy at all, but other court cases do, because they say, well, protecting the Fourth Amendment means protecting privacy. And of course, then, you also get into the question of what privacy is and what does it mean to actually protect privacy, and that's been defined and interpreted by subsequent court decisions. So it's important to understand that we start with the Fourth Amendment, but there are court decisions that interpret the Fourth Amendment to determine whether or not rights should be protected in particular cases, and that's where really the kind of the meat and the potatoes of this debate is about. What does this all mean? It means the resolution asks if a search, remember, that violates privacy occurs in schools and is conducted by school officials. We'll get into that more in a bit. Should these schools officials have to demonstrate probable cause to conduct the search? So let's turn to that next term, probable cause, which is really even more difficult to define than a search. I want to start by making a couple key notes. First is that it's situational. School administrators can't just look up in a book and see if there's a search that they're about to conduct, whether or not it would probably require a probable cause. It depends on the situation where the search is going to be conducted. The second thing that's very important to highlight is that it's even more difficult than the current standard, which is reasonable suspicion. And I'll get into that in more detail when I talk about a few of the major court cases. But right now, school administrators only have to demonstrate reasonable suspicion, all right, of essentially contraband or criminal activity or violation of school rules to conduct a search. That's all that they need to demonstrate. Whereas demonstrating probable cause is a higher level of standard, and I'll get into that more in a minute. How has probable cause been defined? All right, so let's look at this definition or kind of explanation from Dana Bedden. The precise meaning of probable cause is somewhat uncertain. Most academic debates over the years have centered on differences between more probable than not and substantial probability. The former, more probable than not, involves elements of certainty and technical knowledge. The latter, substantial possibility, involves the elements of fairness and common sense. There are more adherents to this latter approach, but how do you define common sense? All right, the Supreme Court has said that rumor, mere suspicion, and even strong reason to suspect are not equivalent to probable cause. So, if a school administrator, usually it's an assistant principal who has, they're the ones usually dealing with discipline. If they just have a suspicion that someone is engaging in illegal activity or has contraband, or they kind of hear this through a rumor, or there's a rumor going around, all right, or just kind of a strong reason to suspect it, that's not really enough. So if a principal conducted a search and probable cause was the standard, and they conducted it based on a rumor or some suspicion, it would probably not be upheld by the courts. The reasonable man, the common textbook definition states, probable cause is where known facts and circumstances of a reasonably trustworthy nature are sufficient to justify a man of reasonable caution or prudence in the belief that a crime has been or is being committed, all right, or sufficient to probable cause of known facts. So we have to have known facts. We can't just have a rumor. We can't just have suspicion or even strongly suspected. There has to be some known facts that are trustworthy, that are present. So, you're a school administrator conducting a search. You hear a rumor, you can't do it. You're just kind of suspicious yourself. You can't do it. But look, if you have strong facts, if you have a picture that another student brings in on a cell phone that shows contraband in somebody's bag, that's a strong fact. If you have some videos of some people exchanging contraband, then there's a reason to believe that contraband is in a particular person's bag. Maybe you have another student just come in and tell you about this. Well, then you get into a question of the student comes in as kind of a reasonably trustworthy source. So that's what you're looking at in terms of probable cause, and I already started explaining kind of what the difference is between probable cause and reasonable suspicion a little bit, but it is laid out here a bit, referencing the TLO decision where it says the court. Usually when the court's capitalized, that refers to the Supreme Court, and it is talking about the TLO decision, which I will talk about next. The court equated the knowledge component of probable cause as raising a fair probability or substantial chance that the known facts imply prohibited activity. Reasonable suspicion requires only a moderate chance of finding evidence of wrongdoing. So there's only it's kind of with the probable cause. You have to demonstrate it's likely that you would find evidence of wrongdoing. With reasonable suspicion, you only require a moderate chance of finding evidence of wrongdoing. Of course, you don't under neither standard do you know that you're going to find evidence of wrongdoing, because if you already had it, then you wouldn't need to conduct the search in the first place. Now, I've been referencing saying, hey, these standards were established by the courts when they were interpreting the Fourth Amendment, but I haven't talked about any of the court decisions yet. So I want to talk now about a couple of the court decisions that are very important in this area. We're not going to have time. There are hundreds, probably over 1,000 court cases relevant to this, but I want to talk about the major ones. starting with the most important one, I think, the court, which was New Jersey versus TLO in 1983. This is a Supreme Court decision. And the facts of the case are pretty simple. Basically, what happened was a teacher claimed to have found 2 female students smoking in the bathroom. This violated a school rule. The 2 students were taken to the assistant principal's office. Again, it's the assistant principal that normally deals with disciplinary issues. The student who was with TLO admitted to smoking, but TLO denied smoking. So then the assistant principal searched TLO's purse and found a pack of cigarettes as well as cigarette rolling papers. Well, usually if you're just smoking regular cigarettes, you're probably also not going to have rolling papers. Since the assistant principal suspected that the rolling papers were signs of marijuana, he further searched the purse and discovered marijuana, a large stack of $1 bills, a list of students who owed TLO money, and 2 letters that implicated TLO in selling marijuana. The assistant principal took all that material, turned it over to the police, because now we're dealing with even more than a violation of school rule, smoking, but actually selling marijuana, which is quite significant. And TLO's attorneys challenged this search, saying the principal didn't have probable cause to conduct the initial search, and the Supreme Court in this case made a few critical holdings. First of all, the court did hold that constitutional rights apply in school. Some of the attorneys who argued on behalf of the school district, the principal in the school in the case, argued that, well, constitutional rights do not even apply in school. The court said, no, constitutional rights do apply in schools, that school students are in a different situation with prisoners who generally don't really have much constitutional rights protection, that they do apply there. So that is kind of an important starting ground. But they did say that probable cause is not required in a school setting. They said that there is a special need to conduct a search, which I'll get into in a little bit more later, and that reasonable suspicion is sufficient. So as I said, reasonable suspicion is the minimal governing standard. That's all schools have to use. They, of course, can decide to have a higher standard if they want, but reasonable suspicion is sufficient to protect students' constitutional rights. They then said that there are special needs exemptions to the probable cause and the warrant requirements. Yes, the Fourth Amendment does say that probable cause is required, but in interpreting particular situations, the court said sometimes there are special needs that districts, that schools have, and other people have to conduct searches where you're not necessarily going to have probable cause. And this actually created what's referred to as a special needs exemption to the warrant requirement, which exists in other places such as employee drug testing, even when those employees work for the government. And fourth, I should have really added right into this slide. Fourth, they said that warrants are generally not required in schools, even if probable cause would be required. That the police wouldn't have to, the school administrator wouldn't have, in this case, most of the time, wouldn't have to get a warrant to conduct a search because it's just kind of too problematic. And there are other exceptions to the warrant requirements, such as when a suspect is fleeing. If a police officer has probable cause, he or she could conduct a search because if the suspect is fleeing, obviously if they went and got a warrant, then all the potential contraband would be gone. But anyhow, that's somewhat relevant to this case and could have implications for the topic, but we'll discuss that a bit more later. But the important thing at this point to know is that the assistant principal, as established by the courts, had reasonable suspicion to conduct the search, and that's all that he needed. Now, there are some subsequent significant Supreme Court cases. I would say probably the next most important one is Vernoni v. Acton, where the court said that probable cause was not needed for random, suspicionless searches of school athletes, right? So the previous case, New Jersey TLO, dealt with individual suspicion of a particular student, right? And the court said that was justified. Reasonable suspicion was not justified. But in this case, Vernoni v. Acton said, look, there's not even reasonable suspicion present, right? It's not that a particular athlete was suspected of having drugs, and we'd just be back in a situation like we were under New Jersey versus TLO, and the courts would be determining whether or not reasonable suspicion was present in that case. But what the court is saying here is probable cause is not needed for random, suspicionless searches of school athletes. So if you're arguing for kind of the people using a probable cause standard for conducting searches, you're not just saying it replaces the individual suspicion expectation, the individual suspicion requirement, individual searches, but you'd also be saying now you can't really do these random suspicionless searches of school athletes anymore, which originally in this case was done for the purpose of controlling drugs. The school argued that there was a big problem with drugs in the school, that there were athletes who were using a lot of drugs, and that since the athletes were the role models in the school, in order to control drugs, they had to control and limit the use of drugs by the athletes, and that's why they should be entitled to these random suspicionless searches. And the court said, yes, you have a special need to conduct these searches. Remember the term special need that I just discussed. And then in Potawatomi, they said, look, you can do this in all extracurricular activities, not just all extracurricular activities, not just sports. Now, you may say this is, that the schools are just out to, that under the status quo law, any types of searches can be conducted. Be very easy to demonstrate reasonable suspicion or come up with a justification for a random search. It's really, I'd say that it's kind of true to an extent. I mean, there is a lot of leeway provided to school administrators, but they can't really just do anything they want. In one case, it's important kind of for the con when saying that it's really not unlimited in the status quo is a case called Safford, in which it was ruled that or held that a strip search of a student was not reasonable. Basically, what happened here was a student she claims basically they found a planner, and that planner had some painkiller medicine in it. It was a little stronger than what you could get over the counter, but not super strong medicine. She got called into the principal's office. The principal said, "Hey, what happened? You have this planner here. You can't have these narcotics in school." The student said, "Well, I lent my planner to someone else." The assistant principal didn't really believe the story, so the assistant principal sent the student down to the school nurse and had the school nurse. This was a female student. The school nurse was also female, and had the school nurse just herself conduct a strip search of the student, and and nothing was found. And the court, this case also made to the Supreme Court. The court said, the court wasn't looking, of course, whether or not the assistant principal had probable cause, because the assistant principal only needed reasonable suspicion. But the court said, look, you don't have any reasonable suspicion, all right, that this student has these terrible narcotics, that you need to conduct a strip search. And I want to go back to the point I made earlier about the justification being situational. Here we have a situation where not only maybe was it not even met the reasonable suspicion kind of test in terms of what was reasonably suspicious, but think about what the item of contraband was. There was some prescription drugs that were maybe slightly greater than what you could get over the counter. This really didn't rise to the level of concern that you would need to conduct a strip search of somebody, which everyone agrees is a violation of privacy and dignity. It's not like somebody came to the principal's office and says that the student was hiding a bomb, and the bomb could go off and kill everyone in the school, that the student was a suicide bomber. There was no kind of a significant threat to the school, to other students, to the disruption of daily activity. Certainly the student shouldn't have had these drugs on her, if she did, but there's not even any evidence that she was selling the drugs. So the court said in this case, look, you can't justify, you didn't really have kind of what you needed to justify this type of search. So the courts do provide some protections for students in the status quo. In the world that we live in now, these students may not think that these protections are sufficient, but they are some, and this is something to point out on the con. Now, I want to talk about next is searches of students. We've already talked about what a search is to a degree, but let's focus on what a student is and what does it mean to search a student. Now that may seem obvious. We're talking about a student is a person who's learning at a school who's under the age of 18. That's or not necessarily under the age of 18, but is enrolled in grades K through 12. Well, what is included in a search of a student? Well, we can obviously agree that a strip search is a search of a student. A search of a student's pockets is going to be a search of a student. But what about a purse, right? And then we're talking about something that's connected to the student, not on the student's body. Just kind of starts to kind of move it away a little bit. Probably still included because it's right on the student at least most of the day. What about a search of a locker? Is that a search of a student? That's a search in a school. Remember, it's a school in pretty much every instance, I would bet 100% of the time, that owns the locker. So is that a search of a student? What about a dog sniff search where a dog's just walking around a school, just walking down the hallway, and the dog goes through to determine if they can detect the smell of any drugs? And then, of course, there's a search of an automobile in a parking lot. Normally the automobile would be owned by the parents, driven by the student, but parked in the parking lot. And then so then we see, is this a search of a student? Now, to some degree, it seems that pretty much all these searches are arguably constitute a search of a student because the penalty is always on the student, right? If the school searches your locker and finds something in there that's not supposed to be in there, you're the one who gets in trouble. So in a conceptual sense, it's a search of a student. But I did find a good piece of evidence that distinguishes between types of searches. Searches of inanimate objects, searches of persons, and administrative searches. The objects included in the inanimate search category include student lockers, desks, luggage and the contents of lockers and desks. For example, bags, purses, backpacks, and binders, all right, if they're in the locker or the desk. So it distinguishes those objects from a person, or a personal search consists of actions such as asking the person to empty pockets, pat downs, sniff searches, strip searches that we talked about, and searches of belongings on a person, right? So all the way up to kind of where we had the purse, that's kind of it's a search of a person or a belonging on a person. I'm not really sure why then above we exclude luggage, all right, or a backpack that's in a locker. I guess it wasn't on the person at the time, but then you kind of start to get obviously into some grave areas there. Then we have administrative searches, are primarily sweeps of persons or buildings. So an administrative search can be a search of a person or kind of, I guess, maybe what they're calling above an object search, depending on where it is. But this is important to note with the affirmative. If the pro starts arguing for particular cases about school lockers, you might argue that those are not topical, that they're not considered searches of students. Now, what does it mean to search students in schools? Again, this seems obvious, but it's not. Because the resolution does not identify which party is conducting the search for the purpose of discussion. What do I mean by that? All right. Normally, as I said, it's a school assistant principal that's going to be conducting these searches. But what if it isn't a school administrator in terms of an assistant principal? What if it's kind of a school administrator, arguably, in terms of what's called the school resource officer? A school resource officer is usually an actual police officer in the area who spends his or her time in a school providing police support in the school. What if the school resource officer conducts the search? Does that school resource officer then need probable cause or just reasonable suspicion? Because at that point, they're not just an assistant principal. They're actually a police officer looking for activity and kind of more directly implicating the law. Then what if the difference is that the school administrator, the assistant principal, asks the school resource officer to do the search? So it's kind of that the school resource officer is conducting the search on behalf of the school administrator. So there's a whole actual line of court cases that deal with whether or not school resource officers can conduct searches either on their own or under the direction of an assistant principal in most cases. Now, most of the court cases have held that they can conduct the search as long as they're acting under the kind of direction of the normal school administrator, the assistant principal. Some of the cases have held that they can't conduct the searches on their own, but others have also held that they can. Just kind of make that decision independently. So when you're looking at probable cause and what types of searches, if you're arguing for the adoption of this probable cause standard, would they apply to? There's a couple things to think about. First of all, that these would then automatically apply to school resource officers as well. And second, you can think about is, could the pro make a case just about how the probable cause standard should apply to searches conducted by school resource officers when those school resource officers are acting to conduct the searches on their own without being under the direction of an assistant principal. And you can find kind of like more evidence on that argument, and you can kind of distinguish that and say, look, we're just saying that the probable cause standard should apply in schools when school resource officers acting independently are conducting searches on their own. And then you can say that, look, to answer the negative arguments, you can say all the other searches would still occur under the reasonable suspicion standard. It depends on whether or not you can run particular specific cases in your area, but if you can, then that's something you might take advantage of. Well, let's now that we've kind of covered a lot of the terms and the content, let's go back to the resolution. In the United States public K-12 schools, the probable cause standard ought to apply to searches of students. The pro has to argue for stronger legal standards that will make searches more difficult. That's the only thing you understand, and remember from what I've said so far, that's the most important thing to understand. The pro has to go against the grain of contemporary law as interpreted by the Supreme Court and other courts. So there are a lot of academic authors writing in law reviews, writing in journals, arguing that the probable cause standard should apply. The pro will be able to find evidence to support that argument. However, the pro also has to realize that they're going against what the courts have ruled, what the courts have decided. So that's where a lot of the negative evidence will come from. And that the pro, you can say, is arguably arguing for the reversal of multiple court decisions, such as New Jersey TLO, Renona v. Acton, the Potatomi decision that applied it to other extracurricular activities, and many other federal district court decisions. That's fine, but that's really, if you were arguing for the adoption of probable cause, that's what you would be arguing for. A lot of times in public forum debate, the affirmative is not, or the pro is not arguing for a change in the status quo. They can just be defending some principle or idea, but you should recognize that the pro is really calling for a radical, or a somewhat radical change in interpretation of the Fourth Amendment. So what are some basic pro arguments? The pro can focus on a few things. First of all, the pro can focus on rights, particularly privacy rights of students, how those rights are being violated in the status quo, why those violations are significant and consequential for students, and why those rights should be protected. Second, the pro can focus on racism and the disproportionate application of what we might call generally the school disciplinary apparatus to black and Hispanic students. There's a lot of evidence that says black students and Hispanic students are more likely to be suspended, they're more likely to be searched, that there's that they're more likely to look for this type of illegal activity or just activity that violates even just school rules going on in the school. And then if we had a probable cause standard, it would be more difficult for school administrators to conduct the searches of those minority students. There's also an argument about citizenship and democratic modeling, saying that if students are conditioned in schools not to have their rights protected, they won't understand the significance of rights, and they'll always come to think that security concerns trump rights considerations, and that undermines, when they grow up and become kind of full citizens, they won't think that rights are important, they won't think that democracy is important. Some teams might articulate that as a spin-off to the rights or privacy argument, but that's the basic argument. The fourth argument that pro teams might make is that it's bad to be preoccupied with security in schools because it alienates students and it undermines a positive school environment. And this argument can get developed in many facets to argue that, basically you're saying that no, we're better if we want to improve security in schools, if we want to reduce contraband, if we want to reduce drugs, if we want to reduce violence, and we need to have a better relationship between the school administrators and the students, and that is the best way to protect it. And since the primary negative argument is really about security in schools and drug use in schools, then it's very important that if pro makes this argument, they're really generating a lot of offense, which you would call offense, against the primary negative argument. If they make this an advantage right out of the gate, it's going to kind of maybe something to their strategic advantage throughout the debate. Con arguments. School security is the primary mainstream argument. We're looking at school violence, that happens and is more severe because you have weapons in schools such as guns and knives. And then, of course, you also have drug usage in schools. Those are the primary reasons that we have a lot of school searches and the status quo in order to control these types of things. The other thing the negatives you're going to look at is a doctrine called parens patriae, which they might articulate as a framework argument in the debate. They're going to say the primary responsibility of the school, all right, is to look out for students. Remember, as I mentioned earlier, under the definition, we're looking at K-12 schools, you're generally dealing with minors. And even when you're dealing with students who are 18, those school administrators are responsible for those students from the time they show up at school till the time they leave the building. And the rationale, one of the strong arguments in favor of continuing to allow school searches is that, if the school administrators are responsible for the students, if there's just a general societal expectation that those administrators are responsible, if they're going to be held legally liable, if something goes wrong in the school, if a student's not protected during that school, then they should be able to conduct these searches. Right? Think about that differently. The police in regular society, they might not have as much authority to conduct a search. But look, if you're a victim of a criminal activity, if you're walking down the street and you get robbed, you can't sue the police department and say, hey, they failed to prevent a crime and I was hurt and injured and the police department has to pay my medical bills. That doesn't happen. But if something happens to you in school and it's something that you can prove that the school had reasonable prior notice of and should have been able to prevent, you could sue the school. So if we're going to be able to sue schools and hold administrators responsible in ways that we don't normally hold the police responsible in kind of society, then we should also be able to say that those schools should be able to conduct these searches. Anyhow, that's an overall framework argument you can make. At the end, in the final focus, you may say, hey, look, if this is a close debate, you need to presume not in favor of rights in a particular school setting. What you need to presume is in favor of allowing the school administrators to have the authority that they need to ensure not only the education of the students, but to ensure the prevention of violence. The third thing the negative wants to do is minimize the violation of rights. All right, as I said, we're dealing with minors in a school setting. And students they have rights in schools, but they don't have as many rights. Look, a student's First Amendment rights are restricted. They can't just go attacking school administrators. They can't go out and kind of promote the free use of marijuana in society. There's another court case about that. They have limited First Amendment rights. They have to go to school in the first place. They're required to do so. Other people in society are not required to go to school. So students don't have they definitely have rights in schools, but they're not, we already kind of agree that they're not as kind of large as the rights protections that we have in other parts of society, simply because they are minors and because it's a school. And of course, there are other ways that people's privacy is violated throughout society. Look at all the past policy debate topic was about Edward Snowden and the intrusion on civil liberties, and there are other actions that impact privacy and race. They arguably potentially have court disadvantages. As I said, this would kind of mean that a number of court decisions would be overturned to have probable cause. So maybe this would undermine the legitimacy of the court or cause a little bit of court stripping where the legislator backlacks against the courts. You could have links to other court cases. As I said, New Jersey, part of what New Jersey, the justification for not having probable cause standard in schools was that the schools had a special need to conduct searches. Well, maybe having probable cause in schools would mean that the special needs doctrine would no longer be justified, since New Jersey versus TLO was the original case. You could debate about whether or not that means the special needs doctrine gets overturned, but then if you don't have the special needs doctrine, then you can't conduct drug searches in other areas. You could make a disadvantage about that. There are critiques of solving racism through the law, which just, I don't think in a public forum you want to make a full-blown critique with an alternative, but there's a lot of good evidence that just says that legal standards are inherently biased against minorities, that, they're always going to find, for example, that the police, or not always, but a lot of the time they're going to find, there was probable cause to conduct a search in this place because the suspect was black. They're not going to necessarily come out and explicitly say that. They're certainly not going to say, the police had authority because the person was black, but they'll say, in this particular neighborhood, there's probable cause to believe that criminal activity was occurring, and it's going to end up being a poor neighborhood where a lot of the people were black. That's kind of just one example. This is kind of a very kind of complex argument, but you get the basic idea that the legal system has a lot of norms and expectations that are inherently biased against minorities, particularly blacks and Hispanics, and you're not going to be able to solve racism by working through the law. There are also critiques of just solving with particular legal standards. For example, probable cause. There's a bunch of literature about what's called critical legal studies that really kind of essentially argues that these standards, when they're adopted in the law, always don't really protect the interests of those who are least well off. And of course, too, as we just mentioned, the minorities, that it's always those with stronger interests who are able to defend the application of the standards in their particular interest. And it's usually the school administrators, right, who are going to be seen by the courts as more credible than the students in most cases, and that those interests are going to win out. Now, as we see with cases like Stafford and other cases, you can see the courts do protect these interests of the students, but it's usually when there's like a pretty extreme violation, such as what occurred in Stafford, which would already be protected under the current law. And so it's not that the pro probably won't accomplish anything, but they're not likely to accomplish very much at all. So those are a few kind of avenues for negative arguments. So in conclusion, remember, in the United States public K-12 schools, the probable cause standard ought to apply for searches of students. This is an interesting topic that is relevant to students and teachers, but it is a complex legal topic. It can be broken down into some simple terms, and it can be broken down into a discussion of terms such as search and probable cause and of students, which is more complicated but provides a lot of explanation and background of the case. So I think it's a very interesting topic that can be debated. I think the topic is pretty well worded, or about as well worded as you're going to get with any resolution which are inherently difficult to word. As I mentioned at the beginning of this lecture, I will be doing a second lecture on the topic that deals with searching students, essentially searching students' social media outside of schools. I know some people, and my original reaction was, this topic might be a bit easier topic because it doesn't have complex legal arguments in it. But I think the legal arguments are just as complex, if not more complex, in that topic, which I'll talk about later. So if you're voting and considering which topic to vote for, hold on until you hear the lecture about that topic, because I don't think the complexity of legal issues should be what decides your vote. Thank you.